Hey everybody, it's Chris Pearce with the Pearce Law Group coming to you from our main office in Myrtle Beach, South Carolina. Today I'd like to talk with you briefly about some recent appellate case law changes in relation to construction. A large part of our practice is involved with representation of contractors, subcontractors, even owners and design professionals on construction projects. One of the issues that we are asked to do very often is to review contracts. And again, if you're a contractor, being able to effectively contract work either from someone or to someone is very important and a regular daily part of your existence as a contractor. What the courts, and specifically the Court of Appeals in South Carolina, through a series of cases has done is they have fundamentally altered what we generally call the indemnification, defense, and hold harmless areas of those contracts. Another area that may be affected by these changes is additional insured status. Those are terms that as a contractor, for better or worse, you should be familiar with. But those are clauses that we're always asked to scrutinize and to look at very carefully because they can create some serious post-contract obligations that some people, quite frankly, don't understand or aren't aware of until it's too late. But with these new Court of Appeals cases, they have moved the pendulum, if you will, more in the direction of the contractors in limiting and significantly limiting the type of the indemnification and defense and hold harmless language that folks can put in those construction contracts. Finally, after years, if not decades, of ignoring this issue, the Court of Appeals basically took it head on through a series of 3 cases. The reality of it is the courts have placed fairly strict and significant restrictions on how that language can be used, how far it can go, and who it may affect and why. And again, if those are documents that you're using on a daily basis, either someone's asking you to sign a contract that has that language in it, or if you're asking someone else to sign your contract and it has that language in it, you need to slow down, stop, and have your lawyer of choice. We would love to be that, but you need to have someone look at those agreements for you and make recommendations on any needed changes. Because the reality is this has been a huge shift in the way the courts look at and interpret and are willing to enforce or not those indemnity defense and hold harmless agreements. So again, the call to action really is if you're a contractor or a subcontractor, or if on a daily, weekly basis, you're either signing contracts or asking people to sign contracts in relation to construction, this is not optional. You have to do this. And the sooner you do it, the better off you will be from several different perspectives, which we'd be glad to discuss with you. But if this is an area of the law that you are involved with, we would encourage you to reach out to us and schedule a consultation so that we can give you some guidance on the language that should be in your agreements now and also the language that should not be in your agreements now. But again, if you've been in the construction industry for any amount of time, you know how onerous and difficult these clauses can be to read, interpret, and if you've ever had them to be enforced against you post-project, you realize how difficult that can be. So let's take this seriously. Again, whether it's us or another attorney, please go have your contracts reviewed in relation to the indemnity defense and hold harmless and additional insured issues. If you don't, you eventually will regret it. I don't know what that's going to look like for you, but this is a huge matter for contractors and owners and design professionals. And the sooner you address it, the better off you will be. We appreciate your time today, and we look forward to seeing you and talking about these issues further. Thank you.